course in the face of that, or will they see this as a reason to pull back in some significant ways?
Well, and another element of that loss of public support, which is critical to the court's legitimacy, of course, is the issue of ethics at the court. And I think I'd like to just have you touch on that before we move to the only potentially optimistic part of this talk, which is reform. You know, obviously the court is having some major ethical issues right now. Justices Thomas and Alito, I think, are leading the pack in that regard. But even, as you pointed out, you used this example of Justice Gorsuch, who literally on the same day that the court agreed to hear a case in which it was going to ultimately hobble labor unions, he gave a speech at a foundation that was funded by the same people who had funded the lawsuit against the unions. So it's very hard to watch that and to read about the stories around Clarence Thomas and Samuel Alito and think that these guys in any way care about how the public perceives their integrity and their neutrality or their professed neutrality. And I wonder, can you tie that issue, the ethics issue, into the broader, the impunity that they seem to feel there, into the broader question of the supermajority and how it was assembled in the first place?
Well, it's the impunity. It's also the corruption of their judgment that it reflects, in the sense that so many of the things they're doing are really problematic on their face, and they don't seem to really see it quite so much. So as Jesse mentioned, and as you may know, in the last year especially, it's become clear that the court has an ethics or even a corruption problem. They're the only court in the country that does not have to follow a binding code of ethics. Some of the controversies that have brought this to light, a lot of them were published by ProPublica, the tremendous online journalism site, nonprofit journalism site. Clarence Thomas in particular, I think we have not yet fully seen all the stories. It's not just that this guy, Harlan Crow, who is a really extreme right-wing billionaire from Texas, it's not just that he, it turns out, provided lots and lots of free luxury trips and lodging and everything like that. And by the way, it's worth mentioning, Thomas disclosed this all, his largesse from Harlan Crow, who had not been anybody he knew until he became a Supreme Court justice. He disclosed this until 2002. Then the LA Times published a story on it, so he responded by not disclosing it anymore, but continuing to take the money. Harlan Crow didn't just provide the trips. He bought Clarence Thomas's mother's house and renovated it with her living in it. He paid for Thomas's surrogate son's education. If we looked at a state capital, if we looked at Albany or Springfield, Illinois, or anywhere, and we saw some state legislator and the rich guy in the town was buying the mother's house, we would say, oh, well, we know what that, look at the corruption there. You know, that's the oldest story in America. That's literally what was going on. And what was striking, especially around this, and also the other story involved Alito, Justice Alito, who was, it turns out, similarly taking very expensive vacations and trips and largesse from a different billionaire, Paul Singer. He said, well, he wrote a pre-Buttle op-ed in the Wall Street Journal, and he needed an editor, honestly, and just, again, it's the arrogance that comes from the lifetime terms. He said, well, yeah, sure, I took this private jet up to go on the fishing trip, but there was an open seat, and it would have gone begging, so it really didn't cost anything. You know, he's in one paragraph he says, of course I can do this because this is a friend and it was just personal hospitality. And in the next paragraph, Alito says, but I can rule on all the billion-dollar cases involving him because I never heard of the guy. And so there's a common thread here which goes to the ideological project and how they got on the court. In the first ProPublica story, there's a marvelous painting of Justice Thomas and Harlan Crow smoking stogies at this luxury resort. And the painting is somewhat ludicrous. It looks like one of those paintings of the dogs playing poker, to be perfectly honest. But there's a third person in the painting with them, Leonard Leo, the head of the Federalist Society, who made, as I'm sure he didn't say, the shidduch to connect Clarence Thomas with his own friendly billionaire. And it's not necessarily that Thomas was a liberal and then he took the trip and then he turned into a conservative, but there's a corruption in the whole enterprise. It was a world of chummy money and ideological synchronicity. And there's a recent story about Justice Thomas going to the Bohemian Grove retreat, which is in Northern California. It's where a lot of men go and they walk around naked, and it's all these business executives and largely Republican politicians. And Thomas went, again, undisclosed to these things, and they interviewed one of the staff working there at this thing and said, well, what did the Koch brothers and what do they all talk about all the time? And the person said, I couldn't really remember. It was some oil company. It was called Chevron. Well, that is the major doctrine to undue regulation that the Supreme Court is about to rule on. I don't think they were talking about where the best gas station was in the town.
Well, and it's also this issue of corruption and as corruption laws themselves make very clear that it's not just about the corruption, it's about the appearance of corruption, right? And that's the important thing, especially with a court. You know, a court's entire legitimacy depends on the appearance of neutral arbiters. And so even if Clarence Thomas wasn't a liberal who would become a conservative after getting, some kickbacks from a billionaire developer, yeah, you feel like it doesn't smell right.
There's no way around it. People understand this more and more. It becomes a self-fulfilling downward spiral.
Right. I want to do, just as I promised, to just touch on reforms and then move to questions from the audience. You end your book by quoting the 3 words that open the Constitution: we the people. And you use these words, and you say they are the most important words in the Constitution. I think in this context, it's because any large-scale change to our system does have to come ultimately from us, from we the people. And I believe in that, I agree with that, and yet at the same time, as I read, the writer Matt Ford wrote recently, we the people have jobs and mortgages and families to worry about. So what do you do about that? You have people who spend all their lives interpreting the Constitution or misinterpreting the Constitution and state and federal laws and nothing else, and then you have the rest of us who very much would like things to be different in many cases, and yet have, jobs and mortgages and families to worry about. What do you do about that?
Well, and it can be exhausting to deal with this. One of the lessons to me from the history of this is that when there is overreach, as I said, there can be backlash, and that backlash can be significantly effective, although it can take a long time. The book talks about some of the ways we, the people, can respond to the court when it seizes power in this way and governs in such a misguided way. One way is voting, and just the general way the political system can respond. There has been already the beginnings, at the very least, of a very strong political backlash to this court. We saw it in the midterm election when the party that controls the White House typically does poorly in a midterm. In this case, running on a reaction to Dobbs, but also fears for American democracy, the Democrats had the best midterm election for a party in control of the White House in decades. We've seen it in ballot initiatives all over the country where reproductive rights especially are being advanced, including in very conservative states. We saw it I think in a kind of very telling way in Wisconsin. So state Supreme Courts, as you know, most of them are elected. Whether that's a good thing or not is a different issue, but most of them are elected. Wisconsin is a very evenly divided state. Not the legislature because it's gerrymandered, but the public is evenly divided, and that includes when they vote for judicial elections. They went from an evenly divided state to an 11-point win for the liberal candidate in April on the issue of the direction of the courts, including redistricting, including abortion. Now, it's worth noting that the Republican legislature responded by saying they were going to impeach her before she put her robe on.
The gerrymandered Wisconsin legislature.
But then, I don't know if you saw this, The Speaker of the Republican-led legislature in Wisconsin asked 3 conservative former state Supreme Court justices to give legal advice on how to do this. And somebody filed a Freedom of Information request, and the advice was, don't you dare do this. It's an outrageous attack on judicial independence, and they backed down this week. So we see it at the ballot box, first and foremost. So we don't have to 24/7 be talking about this, but when the elections happen, as conservatives, to their credit, have done, understand that the Constitution is something that can be affected by how we vote and who we vote for. There's also things Congress can do. Congress, for example, one of the most egregious rulings of the Supreme Court came before this supermajority. It was the 2013 Shelby County case, where the Supreme Court, led by John Roberts, who has a long career of trying to undermine these democracy laws, it gutted the Voting Rights Act of 1965, the most effective single civil rights law that the country had. Congress could restore the full strength of the Voting Rights Act tomorrow if it had the will. In fact, legislation to do that passed the House and actually had a majority of the Senate in the last Congress, but 2 senators, as not surprisingly, Sinema and Manchin, wouldn't change the rules to make it possible to pass. But no Democrat will run for the Senate now without saying, I will change the filibuster rules to fix the voting rights laws. There are even things like constitutional amendments. We have grown very uncreative and timid in thinking about changing the Constitution. You might say, oh, how is that possible? It's so hard to change the Constitution. And everybody always thinks that. And then things get bad enough and you get a burst of new amendments about every 50 years or so, mostly to strengthen democracy, and we're at least chronologically long overdue. And there's a final thing that can be done, which, as I think you might know, the Brennan Center has really been focusing on and pioneering lately, which is state courts. There is an entirely different system of courts than the federal system that can be a bulwark for rights and freedom and protecting democratic equality. I'll give you an example. Every single state constitution but one has a stronger protection for voting rights than the US Constitution does. But state courts have not interpreted it that way. So we have a broad project to try to encourage state courts to step up. We have Republican and Democratic former Chief Justices working with us. We have a publication called State Court Report. And finally, there are reforms that can be made to the Supreme Court itself. Congress can pass a code of ethics. No judge is so wise that they should be the judge in their own case. That's the basic premise of it. Congress could do it, but so could the Supreme Court. And I strongly believe in 18-year term limits for the Supreme Court. The basic idea is that nobody should have too much public power for too long. It's what George Washington taught us when he stepped down after 2 terms. Interestingly, it's really popular. It's really popular across the political spectrum, Republicans and independents and Democrats. It could be done by constitutional amendment, but it could also, I think, be done by statute. And I am not under any illusion that it's going to be a giant group hug were that to occur. The public is bipartisan on this. I don't think, likely that Congress will be. But this is an idea that is, there's a public consensus on it, hiding in plain sight, and I think it's an idea that will become increasingly important. So there is a lot of stuff we can do, but it's not going to happen overnight, but it can have a real impact.
That's great. Thank you for that summary. Could we open it up for questions from the audience?
Hello, I have a question. As we become more politically divided in this country, are we going to become demographically divided between the South and the North? A brain drain from the South. Doctors, obstetricians, lawyers, intellectuals, actors, gays and lesbians coming up north, and other people have dissimilar views going south. Is that a possibility of what's happened in the Supreme Court, or do you think that's not going to come to fruition?
I mean, I think more than north-south now, it's really urban-rural. That's I think, the divide that you're seeing, that you describe, I think, pretty accurately, is that you're seeing that even in what we would call red states. There are these deep blue cities all over the country, and obviously in blue states there are bright areas as well. I don't know what
When you go to a place like Texas and go to Austin, they say we're a blueberry floating in a bowl of tomato soup. The cities are increasingly progressive, increasingly cosmopolitan, but they're surrounded by the polarized rural areas that are becoming more and more conservative. I do think, though, that you've hit on something very important and very troubling, which is we've taken for granted over the past century, but certainly over the past 3/4 of a century, that we're going to build and have one national country, one national set of rights. And the Supreme Court enforcing those rights and the federal courts enforcing those rights, that was a pretty important part of it. It was also the actions of the federal government, whether passing civil rights laws, building the highway system, or whatever. And if, for example, if Congress cannot protect voting rights because of the filibuster, and the Supreme Court will not protect rights, then states have leeway, state governments have leeway to go their own way. And the history of the country tells us that when states abuse the rights of their own people, very often only the federal government has the ability to step in and protect those people. That is the real worry, that we're evolving toward two social systems in this country. Ron Brownstein, the writer for CNN and The Atlantic, he is especially good on this. It's interesting, though, that we all know stories of people leaving places like Texas, leaving places like Florida. There are a lot of people moving into those states as well. The migration of, the Great Migration was the migration north by so many black Americans escaping Jim Crow, and there are many people who've moved back down because of affordability and other things like that. And that's one of the reasons a place like Georgia has become such a swing state with 2 Democratic senators, for example.
Hi. I think this is one of the most important discussions in the last 23 years. I say 23 years because in 2000, the Supreme Court stole the election for Bush. So I don't think the Electoral College should be abolished. I think it should be used to its full extent, and my conclusion is that you only need 150 people to elect the President of the United States. If you follow the rules, mathematically, what's your opinion? There's 3 people in each state, right? 2 people vote for 1 candidate, 1 person. That state's Electoral College votes go. So 150 people, 50 states. That's it.
Well, this is
what about a lot?
Well, you're certainly right that the 2000 election and the Supreme Court's intervention in that election really was a turning point for a lot of Americans in their understanding of the role of the court and their belief in the court as an institution above politics, or even ostensibly somewhat to the side of politics. And they didn't help matters in the ensuing years by behaving very dismissively when asked about the concerns with their behavior. Justice Scalia famously said, "Get over it." So I think that you're right to identify 2000, not just this current, what just happened in the last 8 years, starting with Merrick Garland and Barack Obama, but 20 years or 15, 20 years before that, as a real turning point for the country. With regard to the Electoral College, I mean, yes, I have a whole book about this. You can buy it after the talk. But is this not working? That's better? I'll just say that there have been more than 700 attempts to monkey with the Electoral College over American history. Is more than any other part of the Constitution by a long shot. And there are many efforts underway to use the Electoral College in a different way, not to abolish it, which hasn't worked, although it's come closer than you think, but to use it, for example, to effectuate a national popular vote, which is a whole effort that's been underway for the last 15 or 20 years, and which you can read about in my book. But it's a very it's a very live area, and it's actually an exciting example of American constitutional imagination. As Michael was saying, we've gotten a little timid about our own power to control the system under which we live. And so it's exciting to see people, I think, trying out new ideas, even if they're not going to work, even if 150 people might not eventually elect the president, that we are trying things and seeing and trying to break molds that we've gotten stuck in.
And your book was, I think, really ahead of its time in making the case that there's some fairly profound dysfunctions baked into our system. And these are things that we took for granted as being part of the American political system or the constitutional system. We have the oldest written constitution, but that doesn't mean it's necessarily the only one or the best. And a lot of the time, these things were seen as quaint Americana. The Electoral College, for the longest time, followed the popular vote. But of course, your book describes twice since 2000 what political scientists call the wrong winner won, and it almost happened in 2004. John Kerry almost was elected, and you could argue it almost happened in 2020. But the Electoral College doesn't stand alone. The way the Senate is structured, the fact that it has 2 senators per state, which was very unpopular with most of the founders we revere, they knew what was wrong with that, but at the time of the Constitutional Convention, at the time of the Connecticut Compromise between the big states and the small states, the biggest state was only, I think, 7 times or 12 times,
13 times, yeah.
13 times bigger, the smallest state. Now California is dozens of times bigger than Wyoming. And the filibuster, which is not part of the Constitution, nevertheless used to be used sparingly, but now is routinely used to block all legislation other than the most anodyne things. And then you've got gerrymandering, which again is not in the Constitution, and it's not new. In the very first congressional election, Patrick Henry drew a district to try to keep James Madison from winning a seat. But it's become supercharged by data and digital tools and a greater understanding of polarized voting. And all of this combines with the Supreme Court, with lifetime terms, unelected, it's not a counter-majoritarian institution as an actively minoritarian institution,
yeah.
A place where some would argue a declining demographic group of white Americans can grab on and try to hold on to power using these quirks in our system. And so it really all, there's a book called The Tyranny of the Minority by 2 political scientists at Harvard that really pulls this stuff together. And I think that people seeing this, the way these parts of the system work together, makes them all more alarming when they are seen.
I think of the Constitution sometimes like the New York City subway system, which is it's the earliest example of its kind, and it was revolutionary and groundbreaking and exciting, and it did a lot, but it's aged out, and yet there's this path dependence because we have to use the same tracks, and building new tracks or fixing the tracks takes a hell of a lot of money and a hell of a long time. And meanwhile, newer subway systems are being built that run far better, than the New York City subway system, and so you realize how much you can be stuck in that past. Some people, as we've talked about tonight, want to live in that past, but I think most Americans don't.
Plus, there's the rat with the pizza, which we have that nobody else has.
Right. Were there other questions?
Yeah. Hi. Regarding the issue of credibility and legitimacy and public trust on the Supreme Court, and it seems like, some justices, notably I think Chief Justice Roberts, is very concerned with this issue. And I was wondering, based on the research you did for your book on kind of periods that the Supreme Court goes through, do you think that issue will resolve in any of our lifetimes, and what mechanism do you think it will come through?
So there's no doubt that he is very focused and appropriately so on the credibility of the court. He is an institutionalist. There are times when he votes in a way that we know he doesn't agree with as a political substantive matter because he thinks it's appropriate or he wants to keep the court from just driving off the road in a way that's very damaging. That's not always true. On these democracy law cases until recently in particular, he was just as aggressive as anybody else. But one could certainly see that while he wants the court to steer in the same direction, he has his foot on the brake and his hands on the steering wheel. It's hard to know, given the fact that there's a supermajority, how much that public disapproval will matter. It used to be that the judges or the justices would not be as ideologically lockstep. It also mattered whether something is a 5-4 court versus a 6-3 court. Now, as on the Dobbs case, Roberts voted against the majority, but it didn't matter because he needed to pull someone else along. There is one recent bit of encouraging evidence, though, and I don't know what the basis of it is. I don't know how much is because he's checking the public's reaction. But this past June, I'm writing a chapter for a new edition of the book coming out next June, on this past June. There were 2 rulings on voting rights and voting that were really good. And my organization, the Brennan Center, was in the middle of them. One was on the Voting Rights Act, the remaining shard of the Voting Rights Act called Section 2. People expected that to be really damaged by this ruling, in part because Roberts himself had a career-long crusade against the use of this particular provision, and they struck down a racially discriminatory congressional map in Alabama and did not gut the rest of the Voting Rights Act. That was a genuine surprise. The other one that was a little bit less of a surprise was a case called the Independent State Legislature Theory case, Moore versus Harper, and my group coordinated the Friend of the Court briefs on this. This was a case that said that the Constitution gave state legislatures the power to set the rules for federal elections with no checks and balances from state courts or constitutions or governors or voters passing ballot initiatives, and that nobody had ever noticed this fact before. It was a genuinely nutty case, crackpot idea that would have brought chaos to our elections, and yet 4 of the justices thought it was worth taking the case. By the end, it was so discredited. There were so many conservative voices, among others, like Judge Michael Waldman, the former conservative judge, who called it the most dangerous case for American democracy in two centuries. So that was a 6-3 ruling that Roberts wrote. The celebrations should be limited. They shouldn't have taken the case. All they did was leave well enough alone. But maybe, just maybe, he's adjusting a little bit. But he's only one judge.
And I would also add that this ties back into Michael's point about term limits. I think counting on individual people to bring legitimacy to an institution is always a risky proposition. You need structural reform and structural tools to make sure that legitimacy is maintained. And I think term limits is a great example of a way where whoever ends up in the seat, they're going to be there for 18 years, and then they will leave, and somebody else will come in. Every president will get 2 picks per term. And that kind of regularity, that kind of removal of the arbitrariness of the way the system works right now, where Donald Trump in one term gets 3 picks for president, but Jimmy Carter in one term gets 0, that will be gone. And then I think that by itself increases legitimacy in a way that no individual person's behavior could.
Oh yeah, thanks. You mentioned one of the major decisions of the Supreme Court recently was in the gun rights area, Second Amendment. I have a question about that. So I've always wondered about this, but the introductory clause of the Second Amendment says a well-regulated militia being necessary to the security of a free state, and then it grants people the right to bear arms. So I would think if you were an originalist Supreme Court justice, you might look at that clause and think, well, okay, once the country has an army, a navy, an air force, marines, you wouldn't need the citizenry to be armed like that. But as far as I can tell, the originalist justices, when they're expanding gun rights, never seem to sort of deal with that introductory clause, and I was just wondering what you thought about that.
Well, how many hours do we have? I wrote a book about this very topic. Look, they're flying a flag of convenience. They are originalists because it leads to conservative outcomes. It's not that they are embracing conservative outcomes, I would argue, because it's originalist. You're exactly right that the Second Amendment says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And this amendment, in some ways, is more from a time that's hard for us to comprehend than any of the other parts of the Bill of Rights. At that time, every adult man, eventually every adult white man, was required by law to be in a militia. There was no army, there were no police force. That was how they kept things safe, and they were required by law to own a gun and bring it from home. And that was what, and the people who were opposed to the Constitution, the anti-federalists, as they were called, among other things, were really worried that it was an overreach of national power, that it would have a U.S. Army, and they thought that was tyrannical, and they wanted to maintain these local militias. That was the purpose of the Second Amendment. It was marked up on the floor of the House of Representatives just the same as if it was on C-SPAN. 12 people spoke. All they talked about, nobody spoke about it in terms of individual rights for hunting or self-protection. It was all about, well, should we have a conscientious objector clause? Will the Quakers have bear arms under this provision? It evolved over time. The NRA engaged in a long-term campaign to change how people saw the meaning of this provision. So again, as I said, by the time the Supreme Court ruled in 2008, it wasn't ultimately that controversial to think of it as an individual right. But the purpose of it was emphatically about public safety. They had guns, they had believed in individual rights, but what this was about was public safety. And to give you a sense of the fallacy of the way this originalist project is undertaken, Justice Scalia said, well, keep bear arms. Well, bear means carry. I have a dictionary from the 1700s that says that, and therefore it needs to be small enough that you can carry the gun around. Therefore, you can have a pistol at home. There were a bunch of professors at Brigham Young University, very conservative, who said, well, to help with the originalism, we're going to put everything anybody wrote or said back then into a computer. And so that will enable us to put it all in there, large language model, and push a button. And it's going to tell us what to do now, because it's going to tell us what they thought way back then. And they pushed the button after the Heller case, and it said, bear arms means serve in the military, such as in a well-regulated militia. And their reaction was, oh my God, whoops, like it literally was a term of art referring to serving in the military. So I don't think they're very sincere in their understanding of that provision. And as you mentioned, the NRA lobby.
Well, yeah, I was just going to say, I mean, this is originalism with scissors, which is they literally lopped off that prefatory phrase on the wall of the NRA building in Washington, right? So it just says, I mean, speaking of what you said at the beginning about movie reviews, it literally says ... the rights of the people to keep and bear arms shall not be infringed.
No, it says ...
Right.
They didn't include the third dot because that would have been too much. And I read this somewhere and I said, there's no way this could possibly be true, and I'm going to put this in this book. I'm going to get in trouble. They're going to blow it up on the first day. So I sent a colleague down to the headquarters in Fairfax, Virginia, and so she went to the souvenir store in the lobby of the NRA headquarters, and while buying souvenirs, someone took her picture in front of the wall, so we have proof that it really was true.
But this also gets to a complexity of what we're talking about here, which is public opinion in the court, right? As Michael just said, by the time the court ruled in Heller in 2008 that there is an individual right to bear arms, whatever bear arms means, public opinion was largely there. They weren't doing something crazily out of the mainstream. So when you say the court should be roughly in line with public opinion, you're taking a risk.
Well, and Barack Obama and John McCain both supported the ruling, for example.
Although it's amazing that only a few decades earlier, Chief Justice Warren Burger, when this idea comes up, he says, this is in the 90s, right? The early 90s.
Right, but he was Nixon's very conservative Chief Justice.
Very conservative Chief Justice, following Earl Warren. He says this is the greatest fraud I've ever seen. This idea that the Second Amendment confers an individual right to bear arms is the greatest fraud ever perpetrated on the American people.
But how we deal with the Heller case is an example of a real challenge we face in dealing with the ideas behind originalism and the way the court ruled. After the Heller case, there was one dissent by Justice Stevens that took on the originalism and actually said, no, if you really look at the history, this is really what it was. There was another dissent by Justice Breyer that looked at the consequences. But the question, the challenge you always face is, if they're coming up with a concocted history and the real history is on your side, do you say, no, look, here's the real history? Or are you buying into the idea that history is how we should make decisions today? And I'm strongly of the view that it's a mistake to validate the idea that history, even correct history, is the only thing we ought to be looking at. And we wrestle with this at the Brennan Center, and people arguing in front of the court wrestle with it. Justice Ketanji Brown Jackson very strongly and effectively made, in effect, originalist arguments on the 14th Amendment, which was passed by the radical Republicans as a charter for racial equality, in the arguments on the affirmative action case and voting rights cases. It's also the case that you can't really look at the original history of the 14th Amendment and say it was a charter for LGBTQ equality or women's equality, because it wasn't. So I think there are limits on even the progressive version of originalism, and this is something where conservatives have been robust and Democrats and progressives have been mum. When you watch these confirmation hearings, the Republicans, of not just of Supreme Court justices, but of lower court judges, the Republicans say, are you an originalist? Are you willing to only enforce those rights that are deeply rooted in history and tradition? Do you believe in the dreaded living Constitution, yes or no? And the Democrats say, tell me about your family. Did you love your parents? Did they give you lessons in hard work that you want to share with us? It's a one-sided argument. And I think one of the things that ought to change is that.
Do we have time for one more?
I'm a historian, and I guess I can endorse your view. But I have this question came up in classes, and eventually, if you want to get the Electoral College over the hump, maybe the thing to do is to amend the Constitution so that states with below a certain population can only have one senator.
Well, unfortunately,
that might pass.
Unfortunately, the Constitution itself makes the Senate effectively unamendable. It requires the consent of all states, or no state can be deprived of its 2 senators without its consent. That's in Article 5 of the Constitution. I guess you could amend Article 5, but that opens up a whole other can of worms. So
there's only 2 parts of the Constitution it says that cannot be amended. That, and that you could not prohibit the slave trade before 1808. So they took this pretty seriously to put those 2 together.
But it's an interesting, I like the creative thinking. There were many founders, including the protagonist of my book, James Wilson, who were absolutely horrified by the Senate, by the idea that states, these artificial political entities, would share equality in the governing of the nation. And they wanted, if there was going to be an upper chamber at all, they wanted it to be proportioned by population. They lost that fight, as they lost many good fights. But it's just a reminder that the birth of our nation was actually much more fraught and much more, there were many more debates over some key issues that we still debate today than I think we realize.
And we want to hear that. I will tell you, I am very eager for this book because I think he's an extraordinary in history, and there's nobody to do it more justice than you. So we're looking forward to it.
Well, thank you all so much, and please thank Michael for this great book. Go buy it.
And thank you, Jesse and Michael. Thank you so much. And I want to make a radical proposal that rather than walking this way to talk to them, you go that way, where Michael and Jesse will be towards the front. You can look at their books. They'll talk to you there, sign them. Thank you all for being here.